quickly register your land because it is very important to be the first in time when it comes to claiming title or disputes. Also, if you are acquiring land or throughout your land transaction, keep records. You need to have your receipts, you need to have your searches, you need to have your indenture, your sale and purchase agreement, everything recorded and kept safe for any future issues. When an issue comes up, all these documents will help you and it will determine whether you can win the issue, you can win the case or not, because it would show the steps you took as a prudent buyer to acquire the land. Now, I want to read this judgment from a case known as Kusi and Kusi versus Bonsu. It was held by the Supreme Court in 2010. And the court said that any person desirous of acquiring property ought to properly investigate the root of title of his vendor. In this case, which is the Kusi and Kusi case, there was no evidence of a prudent search conducted by the defendant. In the defendant's own pleadings, they said that they only inspected the title deeds of the assignor, coupled with a permit for construction, and were satisfied. The record does not show that they even sought professional advice before entering into the transaction. In our view, the steps they took are not adequate steps for a prudent purchaser of this particular property. Indeed, had they extended their search to the Lands Commission, Kumasi, the statutory body that kept official records of lands in Kumasi, they would have known that the land was encumbered. So this is what the court said in this case. Sometimes, in your view, your acquisition was genuine. You paid everything that you're supposed to pay. You had your indenture, you had your site plan. They even showed you their own title documents and everything was in order. So there's no problem. But the court is saying here that the defendant was not a prudent purchaser because they did not conduct search at the Lands Commission. So at the minimum, at least, just conduct your search at the Lands Commission and have records of the search. This can protect you so much in case the matter ends up in court. It will show that you were a diligent buyer. Now, let's note these couple of things when it comes to land acquisition. First of all, foreign participation. In Ghana, any agreement that is transferring freehold interest to a non-citizen is void. Also, for non-citizens, they can only hold leasehold interest up to 50 years at a time. Freehold interests that were more than 50 years and held by non-citizens before 1969 were all converted to 50-year leasehold, and the reversionary interest in these lands vest in the precedents in trust for Ghanaians. So since 1969, no foreigner can hold leasehold interest beyond 50 years. This restriction even applies if a non-citizen marries or partners with a Ghanaian. If a company is a non-citizen or under the Land Act, a company is a non-citizen if more than 40% of the shares of the company are held by non-citizens. So we need to take note of this. If you are a foreigner or your company is a foreign company and you're acquiring a land, scrutinize your document and make sure that what is given to you complies with the law. If you're acquiring a land from married persons, you need to note that land that is acquired during marriage is deemed conveyed to both spouses unless otherwise stated. So if one spouse is named, that spouse holds the interest in trust for both unless a contrary intention appears. So jointly acquired land must be applied for in both names unless conveyance specifies otherwise. Single spouse application presumes that the applicant acts on behalf of both spouses. So now I think we can look at the questions that we have and try to address them so that people can have a full understanding of what we are doing today.
Thank you very much, Alberta. We have a few questions for you, but we want to entreat all attendees. Kindly drop all your questions, your concerns in the chat box, and we'll attend to them. Like Ms. Chemi said, it is time for our Q&A session, and so we have a couple of questions. And the first question is, aside Lands Commission, are there any government agencies we need to deal with when buying land?
Yes, so during the presentation, I mentioned that you need to conduct your search at Lands Commission. But when you're acquiring a land, aside the Lands Commission, there is the courts, as I said earlier. There is also Customary Land Secretariat, which registers customary lands like stool lands and family lands. So in addition, and then also we have the Collateral Registry. Sometimes some people would apply for loans and they use their land as security. The security has to be registered at the Collateral Registry. So when you conduct your search at Collateral Registry, you'll be able to find out if the land you are buying has ever been used as security by your landowner or by your seller. So in addition to the Lands Commission, there are so many institutions, or there are other institutions that you can conduct your searches. All you have to deal with. All we have talked about is not exhaustive. So there are so many things that you can also do. There are so many things you can do: Collateral Registry, court, Customary Land Secretariat. You also have your unofficial searches where you go to the land and speak to neighboring landowners and all that. So Lands Commission, yes, but in addition to Lands Commission, there are other institutions and other entities or individuals that you can also deal with when you're acquiring the land.
Thank you very much. We have another question from Felix.